imagine that you are an inventor. If someone steals your invention and registers it under someone else's name as an inventor and a patent holder, without your knowledge, do you lose your property right in your invention after you can no longer file a patent by yourself? Patent derivation is the case where a patent applicant, who is not an inventor nor his successor, derives a claimed invention from the true inventor, and without authorization, files a patent application by fraudulently naming a false person as an inventor. Once the derived patent application is published and the one-year grace period is over, the true inventor can no longer file a patent by herself. In such case, can the true inventor still claim her property right in her invention by demanding the derived patent be transferred to her? Let's look at the tangible property and the copyrightable work. If someone steals your car and registers it under someone else's name as owner of the car without your knowledge, do you lose your property right in the car? If someone steals your writing and registers it under someone else's name as author of the writing without your knowledge, do you lose your copyright in the writing? Is the theft of your invention different from theft of other property? Or is the invention not property? In Germany, France, and the UK, the true inventor and owner can claim a transfer of the patent and or patent application that claims the invention derived from the true inventor if the application was made without her authorization. In Germany, such a remedy has been acknowledged through case law and was legislated as patent vindication in the Patent Act. Similar provisions are found in France and UK. Japan also legislated the patent transfer remedy for derivation victims through the 2011 patent law reform. Come back to the US. US patent law has long been under a unique system in which the true inventor has to file a patent application by herself with the limited exceptions in order to obtain a valid patent. Before AIA, the Leahy-Smith America Invents Act, a patent is invalid if the patent was filed by a non-inventor. The true inventor and owner of the invention can prevail against the derived patent applicant and or patentee only when the true inventor and owner files a patent within a one-year grace period. Through the interferences and interfering patent suits. Correction of inventorship errors are limited to the case where such error arose without any deceptive intention. The intentional derived patent filing does not fall within such requirement. In case of patent derivation, there have been no federal remedies for an inventor who wanted to utilize the derived invention as a trade secret, or who wanted research and develop more than 1 year after the derived patent or its application had been published. Yet, there are plenty of state law cases allowing the true inventor and owner a patent transfer remedy in patent derivation cases. Of the cases in which the transfer of a patent naming a false inventor was at issue, Kennedy versus Hazelton in 1888 is the earliest. Kennedy is not a derivation case. Under a contract, the defendant was obligated to assign his future inventions on a project to the plaintiff. the defendant completed the invention but did not want to assign it to the plaintiff, so asked the third party to file a patent application under the third party's name and made him assign the application back to the defendant. The defendant obtained the patent, naming the third party as the inventor. The plaintiff sued the defendant to claim the patent transfer to the plaintiff. Justice Gray denied the patent transfer and said, the patent, quote, the patent law makes it essential to the validity of a patent that it shall be granted on the application supported by the oaths of the original and the first inventor, whether the patent is issued to him or to his assignee. A patent which is not supported by the oaths of the inventor, but applied for by one who is supported by the oaths of the inventor, but applied for by one who is not the inventor, is unauthorized by law and void, and whether taken out in the name of the applicant or of any assignee of his, confers no rights as against the public. As the patent conferred no title or right upon the defendant, a court of equity will not order him to assign it to the plaintiff. Quotation end. Next, in the Supreme Court case Becker in 1929, Justice Holmes acknowledged that the Justice Gray's opinion in Kennedy on patent invalidity was correct, but Justice Holmes said that the plaintiff, the derivation victim, can request a patent transfer based on wrongful disregard of confidential relations and breach of trust by the defendant. Justice Holmes also ruled that the defendant was estopped from asserting the patent invalidity against the plaintiff. He also said that the true inventor's right was independent of and prior to any arising out of the patent law, and it seems a strange suggestion that the assertion of that right can be removed from the cognizance of the tribunals established to protect it by its opponent going into the patent office for a later title. Citing Becker, there are cases that have allowed the derivation victim to claim transfer of the derived patent, claiming his invention but naming a false inventor. The reason of the remedy is sometimes breach of trust, breach of confidential relationship, constructive trust, wrongful appropriation of intellectual property, trade secret misappropriation, the theft of intellectual property, and restitution ordered as a criminal conviction of the theft of intellectual property. These state law cases based on equity have been saving patent derivation victims from a combination of wrongdoings by invention thieves and a strict federal law inventorship requirement. The case law shows the justice and the richness of the U.S. legal system. Now, AIA adopted the first inventor to file system and changed the conditions of patentability and the patent applicant eligibility dramatically, harmonizing with laws of first-to-file countries. Pre-AIA Section 102F, which provided inventorship as a condition of patentability, has been eliminated. It can be so interpreted that the patent invalidity defense would no longer be allowed on the ground of lack of inventorship in patent infringement cases. Yet, the manual of patent examining procedure states, In the rare situation where it is clear that the application does not name the correct inventorship and the applicant has not filed a request to correct the inventorship, the examiner should reject the claims under AIA Section 101 and 115. Inventor's oath or declaration under AIA Section 115 can be corrected any time, and the patent shall not be invalid or unenforceable based upon the failure to comply with the Section 115 requirement if the failure is remedied through the correction. Correction of inventorship is allowed whenever the improper naming of inventors happens through error, but the Section 116 no longer requires the lack of any deceptive intention on his part. Under new Section 118, if a person other than the inventor files a patent application and is unable to show that the inventor assigned or is under an obligation to assign the invention, the patent shall be issued to the real party in interest, that is, the true inventor and owner, or the person who is a current owner of the invention originating from the inventor. Reading these provisions of AIA, lack of inventorship and the filing by a person other than the inventor is no longer a fatal patentability failure, but the correctable procedural eligibility of the patent application. The U.S. patent system is now requiring inventorship only as the origin of ownership in the invention. Lack of inventorship itself does not cause the final rejection, but the lack of ownership in invention does. In case of rejection under Section 101 and 115, the patent applicant should show inventorship of the true inventor and the chain of ownership originating to him from the inventor. These facts show the applicant's ownership in the invention. If someone other than the applicant shows that she is the real party in interest, the director shall issue a patent to her. She should be able to correct the inventorship error if the naming of the inventor is wrong. Still, under AIA, there is no federal remedies for an inventor who wanted to utilize the derived invention as a trade secret, or who wanted to research and develop more than 1 year after the derived patent or its application had been published. I would like to conclude my presentation with my opinion on the patent transfer remedy for derivation victims in the era of AIA. The patent transfer remedy should be allowed as a claim based on the theft of a property right in invention. Among the lower court cases that allow the patent transfer remedy for a derivation victim, not many, but some cases also based on wrongful appropriation or theft of intellectual property. The Supreme Court Becker and the majority of following cases allowed such a remedy not based on property theft, but on breach of trust, trade secret misappropriation, restitution, and so on. That was because under pre-AIA, inventorship was a condition of patentability. Go back to Kennedy. Kennedy said that without inventorship and filing with the true inventor's oath, a patent would be invalid and there could be no property claims without the valid title of the latter patent. 40-some years later, Justice Holmes in Becker and then its followers saw an equitable property right in the officially invalid, yet it stopped to be asserted invalid title of a patent. Such equitable property was based on the inventor's property right in invention, which had existed before and behind the federal patent system, and was terminated forever through patent derivation. Under AIA, inventorship is no more a patentability requirement, but only an origin of ownership in invention. AIA's provision encouraged the real owner of the invention be granted the patent. If the patent is granted to an unauthorized party in place of the real owner of the invention, the patent is no longer invalid because pre-AIA section 102F has been omitted. Under AIA, it should be so interpreted that the derived patent lacks only the eligibility of the patent applicant and now patent holder. The patent was issued to the wrong person who did not own the property right in invention, which is now embodied onto the letter patent. The current patent holder does not have a clear title, but the true inventor's or his successor's property right in invention does not have any defect. The information of invention is primarily possessed by the inventor. The right in invention can stay in that way as long as it is kept from the public. To assert the right in invention to the public, the invention and the title holder should be visible for the public. For that purpose, the right holder uses the patent system, which is designed for the accountability of the public, potentially being asserted the right in invention. In case of derivation, such system is abused by the deriver, the invention thief. Through his wrongdoing, the right holder in invention loses her chance to apply a patent by herself because her invention is published in the derived patent. Through the derived patent, the public is notified that someone is claiming the right in invention. The real owner's possession of invention is now survives only on the patent document. The derived patent, just as the patent filed by the rightful owner, is the title which notifies the public about the exclusive right in the claimed invention. Only the defect of the derived patent is the name of the title holder and the inventor. Therefore, in order to recover the property right in invention embodied onto the letter patent, the real owner, originally the true inventor, should be able to claim a transfer of the derived patent from the unauthorized patent holder. After the transfer of the patent to the real owner, as well as correction of inventor's name, the patent does not have any invalidity nor defect in title. Thank you very much.
I think this is very important what you're doing because I don't think the derivation right under the AIA was really well thought out. So I just have some random comments. One is I think the history behind it was solve very different problems. One problem was, properly attributing, some of the provisions that you cite besides the derivation right, properly attribute, figuring out who the inventor was, and so I think it comes up in, university settings where you have a professor who claims to be the inventor and the, actual, research assistants, should be also listed as an inventor. But then you do have the trade secret problem that you mentioned. Now, where it hasn't really been thought out is the 1 year time in which to file derivation claim is different than the statute of limitations for trade secret misappropriation.
Right.
So that's kind of an inconsistency that My guess is they want certainty, they wanted, certainty in patents, which meant they went for the shorter period of time. But that is an inconsistency. And the other thing, and I wasn't clear about what you were thinking about this, but, what I'm hearing you say is that the trade secret owner is not going to be able to get compensated under the scheme for the loss of being able to treat it as a trade secret. Is that okay?
As a trade secret misappropriation,
Yeah.
If all the prerequisites are killed, of course they can sue for damages, but the information is already published. So
Yeah, so here's the thing, so I would push back on they don't have a federal remedy. They do clearly have a state remedy for trade secret misappropriation. If I were a defendant in a trade secret misappropriation case in this scenario, I actually have written that I would bring a motion to stay the civil trade secret state claim while the inventor files a derivation claim and tries to get the rights. And then I would also argue that their patent, getting a patent, owning a patent is a better remedy than the trade secret remedy, particularly because most trade secrets would probably cease to exist in the 20-year time of a patent. So I see the concern you have, but I'm wondering if in real life will actually arise that much.
let me answer very quick. So if the patent holder, patent applicant added some value into the invention or trade secret, then restitution can be used. The cost for patent filing also can be come back. But on the other hand, the trade secret holder could have kept it forever, but lost for a limited time. So damage can be deducted in each other.
Yeah, I see that point now.